A lot of gun owners are waking up to scary headlines saying the Supreme Court just dropped an emergency ruling that could wipe out permit discretion across America. Pause. And if you trust the wrong headline, you could walk away, thinking the law changed overnight when it actually did not. Quick question before we continue. Are you subscribed? Because this channel is where we separate panic, rumor, and clickbait from the court record that can affect your freedom. Hit that button right now, because what I'm about to explain could stop you from making a very expensive mistake. Here's what just happened, and here's why this matters so much to you. First, there's a real reason people are talking like this. The Supreme Court already made a huge nationwide move in the 2022 Bruen case. That was the case where the court struck down New York's old proper cause rule. In plain English, that rule meant you could meet the basic requirements, but the government could still say no unless you showed some special reason to carry. The court said that was unconstitutional for ordinary law-abiding people who wanted to carry for self-defense. Now, that part is real. That part is big, and yes, it hit permit discretion nationwide because it told states they cannot make you beg for a special need just to exercise a constitutional right. That is the major earthquake, not a brand new mystery order from last night. The court in Bruen basically said there is no other constitutional right, where you have to convince a government officer that you have some unusual need before you can use it. That changed the map for every state that used a may-issue style system. But here's the crazy part. Bruen did not say every permit system is gone. It did not say every state has to go permitless, and it did not say states cannot require objective things like background checks, fingerprints training, or basic paperwork. In fact, the court went out of its way to say shall-issue systems can still exist if they use objective rules instead of open-ended personal judgment. That is where most people get this wrong. They hear discretion is dead, and they think all permits are dead. No, that is not the same thing. Most people think the fight is over because Bruen already won it. But the truth is, states started changing the game right after Bruen. They stopped saying, prove special cause, and started saying, fine, we'll issue permits, but we'll bury you in new rules, sensitive place bans, moral character reviews, social media demands, and private property traps. Let me break this down for you with a simple example. Imagine you live in a state that says you can get a carry permit if you pass the background check, finish training, and meet the age rule. That sounds objective. But now imagine the same state quietly adds a rule saying an official can deny you because they don't like your character, or because you carry on to almost any private property open to the public unless the owner gives express permission first. Suddenly, you may have a permit in your wallet, but your real ability to carry is being squeezed from every angle. That is why this story matters. The big national question is no longer just who gets the permit. The next question is whether states can make the permit almost useless after they issue it. If you're finding this helpful, imagine what you'll learn in my next video about the exact words to say when an officer asks whether you're armed. Subscribe so you don't miss it, because the people who stay current are the people who stay out of trouble. Now this is where it gets interesting. After Bruen, New York passed a new law called the Concealed Carry Improvement Act. And gun rights challengers said, hold on, this is just the old system wearing a new shirt. They argued that New York replaced one kind of discretion with another. Instead of saying proper cause, the state started using things like good moral character, interviews, references, social media disclosure, and a long list of places where carry was banned. So what did the Supreme Court do on emergency review? This is the part that shocked a lot of people. In early 2023, challengers in a case called Antonyuk asked the Supreme Court to step in on an emergency basis and lift a lower court stay that was keeping much of New York's new law in force. The Supreme Court denied that emergency request. Read that again in plain English. The court did not issue an emergency order wiping out permit discretion nationwide. It denied emergency relief in that New York fight. But wait, there's something even more important. Two justices, Samuel Alito and Clarence Thomas, said the New York law raised what they called novel and serious questions under both the First and Second Amendments. And Alito made a very important point. He said the denial should be understood as respect for the lower court's process, not a decision on the merits. In normal English, that means the court was not saying New York's law was fine. It was saying, we are not stepping in right now at this moment through emergency action. That difference matters. A lot of headlines blur that line. An emergency order is not the same as a final ruling after full review. If you miss that difference, you can badly misunderstand where the law stands. Here's a hypothetical example to explain this. Imagine your school principal says, I'm not deciding this today. I'm sending it back to the vice principal for a fuller review. That is very different from saying, I approve what happened. That is basically the problem with a lot of online coverage.